group.
Registrar only one.
Yeah, I know. For the government group, you need to elect one of the registrar. You not reply me on. Okay. Halo. Halo, kumpulan Nazhan, kumpulan Srijong. Who is the registrar?
Fawaz is a registrar.
Fawaz, okay. Okay, registrar. Fawaz need to start the proceeding. Okay, Josh.
Okay.
All ready? Okay. I hope that only this person open the camera. Ain'ni, Chai Swijong, Mama Fawaz, Siti Wan Midat, and then Muhammad Faikmal, Nur Fazilana, and then Teh Susan. Only 7 open the camera. I also will close my camera.
Okay, and then I think the registrar also should warn the other group, about timing.
Okay, 50-minute proceeding. Once the registrar already mentioned about the case to the judge, to the court, and then from there we count 50 minutes. Okay, I give to the registrar to start, and then to the judge. Only 7% on the camera. Okay, thank you.
Wait, Dr. Anwar, are you recording the session?
Oh, no, Chair, sorry. Thank you for reminding.
Okay.
Okay, now I got start. Okay, registrar.
Registrar, you can start now.
Hello, can you hear me?
Yes.
Okay, welcome everybody. I would like to greet the team of counsel and the team of the legal advisor, as well as other cast members who are attending the hearing this morning. I would like to introduce myself. I am Muhammad Fawaz, acting as the registrar of the court. Today we are sitting to appeal on a appeal session regarding the court proceeding number UM01, land reference number of S5-1501, between the appellant Datuk Silva Raju, anak lelaki Kunju Kilai, against the defendant, land administrator of Wilayah Persekutuan Kuala Lumpur. Now the courts will commence. Legal advisor from the defendant, please introduce yourself and your assistant.
Thank you, Registrar. My name is Chai Srijong, Senior Legal Advisor at the Attorney General Chamber, Putrajaya, and my assistant, Ms. Nurul Ain'ni Kamaruzaman, representing the respondent, and Administrator of Wilayah Persekutuan Kuala Lumpur.
Thank you, Legal Advisor Mr. Chai. Now is appellant lawyer from the plaintiff turn to introduce yourself and your assistant.
Thank you, Legal Advisor Mr. Chai. Now, may I please the court, Your Honour. I am Muhammad Faikmal bin Zainal Abidin, together with my learned co-counsel, Mr. New League One from Zaid Ibrahim & Co., appear on behalf of my appellant, Datuk Silva Raju, anak lelaki Kunju Pulai, in the present case before this Honorable Court.
Okay, thank you, Mr. Fai. And now you may introduce your case and your ground of appeal.
Sure. Your Honor, this is reference to a High Court case related to the amount of compensation given by the land administrator to Datuk Silva Raju Anak Lelaki Kunju Pulai for the acquired land scheduled on the Form D. Due to inadequate compensation received by the appellant, we would like to refer to court to challenge the valuation report prepared by the government valuer during the inquiry dated on 21st July 2015. We would like to appeal the decision of the land administrator due to these facts and following ground. Firstly, government's valuer, main comparable and supporting comparable. Secondly, government valuer's adjustment for individual's affection. And lastly, zoning stated in comparable 4 is inappropriate. Now, Your Honor, I would like to call upon my witness to the stand, Surveyor Teh Shuzhen, a registered valuer from VPC Alliance, Kajang, to come to the stand for the examination.
Okay, now the appellant witness, please read this oath.
I, Teh Shuzhen, do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
All right. Thank you, Surveyor Shuzhen, for attending as a witness for today's proceeding, and I would like to conduct an examination on you in regard to this case.
Sure, no problem.
Okay. Firstly, could you tell the court your designation?
Yes, I have been involved in this industry for more than 41 years and registered as a registered valuer as V125. And I was a Director General of the Valuation and Property Service Department, Ministry of Finance, Malaysia previously. And now I am a Resident Director of VPC Alliance Kajang Sendirian Berhad. And throughout my career, I was also active in the property management as well as the estate agent sector.
All right, thank you, Surveyor Shuzhen. Now, I would like to require you to describe the valuation carried out for this case.
All right. I was instructed by my client, Mr. Datuk Silva Raju, to carry out this valuation for the scheduled land. Actually, the land was acquired for public transport purpose on 7 April 2016. And the public transport is actually the construction for MRT station. And for this valuation, I have conducted the valuation using the market approach, which is the comparison method. In this case, I think the comparison method is the most appropriate to be adopted. And I have chosen 4 most suitable comparables to assess the market value of the scheduled land. So in the end, based on my opinion and justification, the market value of the land is 500 ringgit per square foot. And on the other hand, I have also conducted this valuation based on 2 basis points. So the first one, I assume that the whole portion of the undivided share of my client is being acquired. So there will be no injurious affection and severance claim. Next, I would like to talk about the second basis, which is I assume that only some part of the undivided share will be acquired, and therefore there will be claim for injurious affection and severance. So based on my justification, I have adopted the first basis, which is without the injurious affection and severance claim, since the undivided share held by my client is small. So I assume that the whole portion held by him will be acquired fully.
Okay, thank you. And just now, you have said that through your analysis, you said that the market value of the scheduled land is 500 per square foot. Can you elaborate how you assess this value?
Sure, no problem. So I conclude the value of 500 ringgit per square foot based on my own opinion and justification. So based on my valuation, the adjusted value of all of the comparables ranges from 488 ringgit to 668 ringgit. But in fact, I didn't select any of these exact adjusted value directly from any of the comparables. But I also didn't average out or take the weighted value from the comparables. Instead, the value of 500 per square foot is concluded based on my own experience and justification. So during this valuation, based on my finding, the subject land is located in a fast developing commercial area. So the neighborhood of the site is mainly commercial and residential. On the other hand, most of the roads around the scheduled lot has been upgraded. And I found that there's a few highways crisscrossing in this area. So this development has brought much uplift to this area. Whereas for the locality of Jalan Ipoh, this area is being turned into a commercial development area. On the other hand, the scheduled lot is located at the first layer with the frontage to Jalan Ipoh. So, in my opinion, this lot is having a great potential for commercial development. And also, based on my analysis, the prices of the transactions that occurred over the past year showed an upward trend. So this indicates that there's increasing demand and increasing value for the land in this area. So based on all of these findings, I concluded the value of the subject lot to be 500 ringgit per square foot.
All right. Based on your opinion and after you have read the report prepared by the government, do you think the amount of compensation given by the government valuer is adequate and fair to the person interested?
All right. In my opinion, no, because the market value given by the government valuer is about only 240 ringgit per square foot for the scheduled land acquired, which is much lower compared to what I have valued, which is the 500 ringgit per square foot, like I mentioned just now. So even adding up the 20% of market value for severance and injurious affection claim, as mentioned by the government valuer in their report, the final compensation award is also just only 336 ringgit per square foot, so which is still much lower compared to my valuation.
Okay, thank you, Susan, for the cooperation.
All right, thank you.
Your Honor, now I would like to do a cross-examine the government valuer. Now I would like to call upon the government valuer to come to the witness stand.
Okay, now the respondent witnesses, please read this oath.
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth and the whole truth and nothing but the truth.
Thank you, Surveyor Ain'ni, for attending as witness for today's proceeding, and I would like to conduct an examination on you in regard to this case. Your Honor, we submit that our first ground is government valuer's main comparable and supporting comparable. Surveyor Ain'ni, it stated in a valuation report that comparable to is the best comparable despite the fact that comparable to is having a total 90% adjustment, which is the highest compared to the rest of comparables. The choice of comparable to by you merely due to the reason that comparable to is located near to the scheduled lot is unreliable. So my question is, based on your explanation, you say you choose this comparable because it is nearest to the scheduled land. So you mean that you have been applying this principle since the beginning to become the valuer?
No, comparable to is chosen as best comparable other than the reason of located with the vicinity because it is the only comparable which has the same category of land use, express conditions, and same locality with the scheduled land other than comparable for. According to Nanyang Manufacturing The main principle of determining market value is considering the price of sales of similar land in the neighborhood or locality.
Okay. It is common practice that as a valuer, so far as I know, the basis of choosing comparable is with least amount of adjustment factor and having lowest adjustment amount as the best or main comparable. This principle is even well known by the valuer regardless of your experience. Can you justify that?
Can you repeat your question again?
Okay, I repeat. As far as I concern, it is common practice that as a valuer, the basis of choosing comparable is with least amount of adjustment factor and having lowest adjustment amount as the best or main comparable. This principle is even well known by the valuer regardless of year of experience. Can you justify that?
I understand your concern, but for our case has a special circumstances where there is a very minimum of past transaction, only comparable to has the same category of land use, express condition and locality with the schedule land among the comparable. Therefore, I don't see any problem in selecting comparable 2 as the best comparable. Moreover, the high adjustment percentage is fully achieve the higher and best use principle based on the MVS. Once again, I don't see any problem in my lawful action.
Okay, but do you know a high percentage of adjustment shows that high degree of dissimilarities between subject lot and the comparable, which is indicate that particular comparable is no longer suitable to be used.
The percentage of adjustment was mainly contributed by 5 elements, namely density, size, quantum of size, shape, and development, which make up of 65% of the total adjustment. All these elements are closely related to the future development of the schedule land. The reason to have a high adjustment is because we take into account consideration of higher and best use, which is residential development, since the zoning of the schedule land is residential instead of referring to the current undevelopment situation of the schedule land.
So do you still believe that with the high degree of percentage can be the best comparable, can be the best main comparable, despite of the principle in adopting the comparison method?
I did explain just now our case is under special circumstances where only comparable to have same category of land use, express condition, and within the same locality. So I see no problem in choosing comparable to as the best comparable.
All right. Okay. Surveyor Ain'ni, other than choosing a main comparable, you also choose comparable 4 as your supporting comparable. Can you give your justification on choosing this transaction as one of your comparable?
Comparable 4 is used as supporting evidence is mainly because we use it to verify the amount of compensation by not giving a lower compensation amount in terms of price per square meters compared to the previous transaction of schedule and since is the past transactions.
All right. Do you think zoning and density is actually an adjustment factor that should be focused on?
Yes, because we need to value the development potential based on zoning.
Then why do you don't make any adjustment on it?
Can you clarify it? I don't quite understand.
My question is, based on the answer that you have just said now, why do you don't make any adjustment on it?
You mean the zoning or what?
Yeah.
Because our zoning is residential zoning, I don't see we need to make adjustment on it. And the comparable is also residential zoning.
All right. Besides, are you aware that the transaction of comparable 4 is actually an undivided share between vendor and the seller?
Yes.
But are you aware that the transaction is actually not an arm's length transaction?
No. It's unlinked transaction based on our analysis.
What? Sorry?
I say after we analyze the transaction, it's unlinked transaction.
Can you repeat again? Sorry, my connection.
I say after I analyze the transaction of comparable for is unlinked transaction.
Okay. So after you analyze your comparable for its unlinked transaction, so do you think before you analyze the transaction, it is not an unlinked transaction, and it did not reflect the market value accurately. So can you justify that?
Can you show me evidence that the transaction is not unlinked transaction?
I'm sorry, it is up to me to show the evidence or not.
Can you repeat the question again?
I repeat, since before you analyze the comparable, it is not an arm's length transaction, so it did not reflect the market value accurately.
It did affect the market value accurately.
Okay, if yes, why you choose this is as a supporting comparable again?
As I said just now, using comparable for is as supporting evidence, which is mainly to verify the amount of compensation by not giving a lower compensation amount in terms of price per square feet compared to the previous transaction of the scheduled land.
Okay.
Council, I would like to make an observation here. Seems that now your communication with the witness is like a two-sided thing between you and the witness, and not for the benefit of the court. So I would like to make a formal observation here that I am requiring you to address the court rather than pestering the witness like this. Okay, I would like to know where your line of questioning is directed. Huh? What's the purpose of your line of questioning?
Okay, Your Honor.
Okay.
Okay. See, this is the evidence for the arm's length that I said just I said just now. It is not an arm's length because the transaction occurred between the co-proprietor. There is special relationship between the buyer and the seller. So, for comparable for, it is not the best comparable to be a supporting comparable. As you can see in the screen, Abdul Hamid bin Awang and the pembeli Semai Srijaya Sendirian Berhad.
Yes, as I know, for this land got a lot of proprietor, but can you show that two of the proprietor has relationship?
Sorry, can you repeat again?
I mean, this scheduled land got a lot of registered proprietor. Can you confirm that and ensure that there are relationship between the two parties?
Sorry, your answer is quite irrelevant for me to answer it. Alright, okay, continue to the next. Okay, Your Honor, proceeding with the case, we would like to proceed with the second ground, which is the government values calculation for the injudicious affection. Okay, Surveyor Ain'ni.
Objection. Your Honor, counsel question is irrelevant to the case. The severance and injurious affection is not claimed by the appellant according to the PV evaluation report and what they mentioned just now. Since the ground of objection of appellant is to increase the value of compensation, I don't see this matter relevant to increase the amount of compensation.
I would like to see where the council's questions will lead to. So I will allow this line of questioning, and then I will stop if it's irrelevant.
Sure, thank you.
So may I proceed?
Yes, you may, but I will stop you if I find the line of questioning irrelevant to the case. Okay?
Right. All right. Very kindly, in your report, you are recommended a 20% of a market value of unacquired land for the compensation of the severance and injurious affection claim. Government value has failed to take into account the damage accrued at a deeper level. In regard to this, only 20% of the market value for the remaining land claimed under the severance and injurious affection is not enough, and the degree of damages they have suffered is much higher than it was stated in the government valuation report. So, very kindly, in your report, you recommend that 20% of market value of the unacquired land of the compensation of the severance and injurious affection claim. Can you further elaborate the 20% compensation breakdown?
Okay, first of all, I need to say there is no point to discuss this because your claimer portion is fully acquired, but I still explain for the the breakdown of percentage. First is the accessibility. 5% is located for accessibility because Jalan Ipoh is the main route access to scheduled land, and there is no access to from Jalan Ipoh after acquire. Therefore, 5% of surance claim is awarded under this element, and this percentage is reasonable because there will be MRT, which is another way of accessibility after the acquire. And then the next element is second layer. The scheduled land was previously at the first layer along Jalan Ipoh. Upon acquisition, it will become second layer as shown in the evidence in the report, our valuation report. Therefore, 5% of surance claim is awarded under this element. And the next element is size. The size of scheduled land is almost 3 acres. Upon acquisition, the remaining land size become less than 2 acres, and it is not uneconomic for residential development. Therefore, 5% surance claim is awarded under this element. And the last element is shape. As the shape of scheduled land is previously elongated, rectangular shape, which is good for residential development. Upon acquisition, the remaining shape become uneconomic for residential development as shown in the report. Therefore, 5% of surance claim is awarded under this element.
Okay, then have you ever thought of the irreversible damages going to happen to the unacquired land in a deeper context due to the acquisition?
For example?
For example, the acquired land becomes smaller, and for the what we call there's no potential development going to be happen, especially in residential because due to the construction of the MRT. So my question is, do you ever thought of the irreversible damages going to be happen to the unacquired land in the deeper context due to the acquisition?
I did take into account of the undevelopment for residential development in the future. Therefore, 5% is accounted for that.
Okay, good. I'm glad that you have thought of the above mentioned reason, and I would like to further enhance your answer. As you answered before, based on your argument, Your Honor, I would like to strengthen that the claim for injurious affection and severance just for 20% is not enough. Based on my appellant witness, the compensation for these two damages should be 70%. Okay. Your Honor, my third ground of rebuttal is zoning stated by the government valuer is inappropriate. In your report, the zoning of the scheduled land is perumahan stabil and pengangkutan. Based on explanation and information given by them, the information of the zoning is obtained from the City Planning Department of DBKL. So, Surveyor Ain'ni, do you know you have provided incorrect zoning for scheduled land as you obtained the information dated on 26 July 2016 provided by the City Planning Department of DBKL?
I did. What can you explain your question again?
Do you know you have provided incorrect zoning for scheduled land as you obtained the information dated on 26 July 2016 provided by the City Planning Department of DBKL?
Okay. I aware of that. When I obtained the zoning plan from DBKL Planning Department, I specially mentioned that to DBKL Planning Department to give me the zoning plan on 21st July 2015. Moreover, the officer also double confirmed with me that there is no changing on the zoning of the scheduled land. Yes.
Sorry, can you repeat your answer?
Okay, I say I aware of that. Therefore, when I obtained the zoning plan from DBKL of Planning Department, I specially mentioned to the officer that to give me the zoning plan on 21st July of 2015, which is the valuation date.
Okay, since the date of valuation is 21st July 2015.
Your Honor, I want to inform you that the council team time messed up. The floor now may proceed with legal advisor.
Okay, I will allow for the appellant lawyer for the council, Pak Iqmal, to just give one statement to conclude the witness statement just now, and then pass over to the other side to legal advisor. One statement from you, Lawyer Pak Iqmal.
Okay, Your Honor. Based on what explained by the defendant witness, Surveyor Ain'ni, our stand is that the zoning of the scheduled land should be commercial zoning, as stated in our report on the date of valuation of the scheduled land. The differences of the zoning between the appellant and the defendant is because the defendant has obtained the zoning information based on the newly published draft of PBRKL 2020, which was not gazetted at that time. All right, that's it for the appellant. Now I will pass to my esteemed colleague, Mr. Choi.
Thank you, my esteemed colleague, Mr. Faiq. Our ground of objection is to object the increase in the compensation claimed by the appellant due to the unlawful practice of private valuer. Now, I would like to call to stand my witness, Surveyor Ain'ni, a registered valuer from JBPH, to examine my witness. Surveyor Ain'ni, can you please tell me which university do you get your educational certification?
I'm graduate from UM in degree and master, and later I finished my PhD in University of Reading. Yeah, in PhD of Real Estate and Planning.
Sure. Then I would like to ask, how long do you work as a valuer?
I already worked for 10 years, particularly in JPPH, and also several years in valuation company, and I expertise in land acquisition methods.
Sure. Now, I would like to ask you, is there any problem regarding the best comparable chosen in your valuation report?
No problem at all. Actually, comparable for is merely a supporting evidence, as I mentioned just now, and comparable to is the best comparable because it is the only comparable which has the same category of land use, express condition, and within the same locality with the scheduled land. Choosing basis is definitely correct. Besides, potential value is considered to achieve highest and best use according to Malaysia valuation standards. Therefore, my compensation value awarded shall be adequate.
So, do you want to clarify on the arm's length transaction mentioned just now?
Before I conducting the report, I did analyze all the transaction and justify it. I see no such arm's length transition problems in the comparable.
Sure. Is there anything else regarding a valuation report that needs to be clarified?
My zoning plan is lawfully obtained from DBKL Planning Department based on Section 9A Land Acquisition Act shall serve as conclusive evidence. DBKL Planning Department already double confirmed with me that no updating on zoning for scheduled land from 2011 onwards. Therefore, the scheduled land is lawfully zoned under residential.
Thank you, Surveyor Kindly, for your cooperation. Now I would like to call upon Ms. Surveyor Susan to conduct a cross-examination on appellant witness. Ms. Susan, according to Malaysia Value Standard, category of land use is the minimum requirement for the comparable sales. Under Rule 75 of Valuer Appraisers and Estate Agents Rules 1986 stated that all valuation reports shall comply with the Malaysia Valuation Standards. I suppose the whole valuation report shall be unlawful due to the missing of category of land use for comparables. Therefore, I would like to confirm with you if the category of land use are shown or not in the comparable table.
I have to clarify that I have described the category of land use in my valuation report. All of the comparables are having the category of land use, which is building. In my valuation report, the term jenis hartanah actually means the category of land use, whereas the term of pembangunan refers to the building. So I don't see any problem that I don't include the description for the category of land use.
Sure. So may I ask, is that the pembangunan just merely grammatical error?
I don't think this is a grammatical error because as my experience, I always use the term jenis harta tanah to represent the category of land use, whereas the term pembangunan to represent the building. I don't see any point to have argument on this.
Sure. Then can you specify the element in comparable table as express condition, as if it is also a minimum requirement under MBS?
For my as far as I'm concerned, these comparables do not have any express condition stated in their title. So I don't include this part into my valuation report.
So I would just want to lastly confirm with you that all of the comparables are of building category of land use. Am I correct?
Yes.
Sure. In your experience, under normal circumstances, where we can find similar transaction of the comparable with same category of land use, we shall not use other comparable with different category of land use. Am I correct?
Yes.
Yes. So can you tell me what is the actual land use of the scheduled land?
The actual land use of the scheduled land, you mean the category of land use is?
Yes.
All right, the category of land use is new.
So do you think new stand for anything?
New doesn't represent anything.
Sure. In fact, you have already severely misinterpreted the actual category of land use. Our land is alienated before the commencement of National Land Court, and its title is under Geram Mukim. According to Section 53 of National Land Court, it shall impliedly be used for agricultural purpose only. This statement is further supported by its quick rent rate. According to both cases of Amitabha Guha and Semenget Jaya Sendirian Berhad, comparable with different category of land use shall not be used. Therefore, the whole comparable table shall be unusable and the compensation amount shall be unlawfully overvalued. To my next question.
Sorry, can I
yes, can.
have an argument on this?
The legal counsel have pestered my witness.
I already finished my question.
Yeah.
Can I proceed to my next question?
Yeah, in my opinion, the counsel was late in objecting. So may continue with your question, legal advisor.
Okay.
Your Honor, can I still have clarification on this ground, on this issue?
Okay, you may.
All right. Just now, legal advisor stated that the land is alienated before the commencing of National Land Court. But in the land title stated that the land is alienated after the commencing of national land court. So I don't think that this land should be classified as agriculture use.
Actually, the land is alienated before the National Land Court. How we see that? Because it's Geramukim, GM. This one is under country land. So, as for country land is alienated before the National Land Court. The debt shall be no, it shall be no regarding purpose. So for my next question, do you agree with me that DPKL Planning Department is the rightful place to obtain zoning plan according to Section 9A Land Acquisition Act?
Yes, I would like to clarify that specifically to the City Planning Department of DBKL, not DBKL.
Sure. Then according to Section 101 of Evidence Act, the burden of proof is on plaintiff. Besides, according to case Ong Yen and Ano, uncertified documents do not provide authentic proof. Therefore, since you say that the zoning is commercial, can you please show us that the updated zoning plan, which shows that the schedule land is already under commercial zoning, or else the whole accusation is unlawful? Can you show us now?
All right. I admit that my mistake that I didn't provide any clear description on the zoning, and I did not provide the evidence of the zoning plan. But I am certain that I have obtained this information from the DBKL. And the officer in the DBKL office told me that this land is zoned under commercial use. And this zoning, I'm certain that it is as at the date of evaluation of 21st July 2015, sorry.
Sorry, you are not certain with this zoning. In the rebuttal report, you state that high possibility of changing zoning. The word high possibility already showing that this is merely assumption. The appellant is unable to give certified documentary evidence, and this has already contradicted to Section 101 of Evidence Law. However, we are able to provide lawful evidence, which is certified zoning plan, and this is lawfully acquired according to Section 9A of Land Acquisition Act. Therefore, the whole accusation is unlawful, and the residential zoning shall stand. Next question. The town and planning details are considered as additional information that are useful and shall included in the comparable table under MVS. Therefore, I would like to ask, what is the zoning of all the comparable? Can you explain to me?
All right, for this zoning, I have used the term planning to represent the zoning factor. So for the zoning, comparable 1, 2, and 3 is zoned under 1, 2, and 4 is zoned under residential use, whereas comparable 1, 3, and 4 is zoned under residential use, whereas comparable 2 is zoned under industrial use. Unlike assumed in the rebuttal by GV that all the comparables are zoned under commercial use.
Sure. Then do you agree with me that zoning can affect the potential value of a land in general valuation cases?
Yes, I agree with you.
So do you realize that your misinterpretation of zoning as commercial has caused the total compensation amount to be extensively overvalued? Since you say that just now some of the comparables are under commercial zoning, and we already proved that the zoning is actually under residential use.
This is not my fault actually to get the zoning of commercial use, because this is the information given by DBKL. So according to first schedule of Land Acquisition Act, any information given by DBKL shall serve as the conclusive evidence. So I don't think I have any problem in making the valuation workings. So according to the commercial zoning as provided by DBKL, I have made all valuation according to commercial zoning. And it is not my duty that to find out that whether the zoning is correct or not, because the zoning information is provided by the DBKL.
Your accusation on DBKL is unlawful because DBKL is able to show us the zoning plan on the date of valuation, which shows the residential zoning. There's no possible that they cannot give you the same zoning plan. I assume you didn't go to DBKL to get your zoning plan. So therefore, according to case Kuala Lumpur Kepong Berhad and JW Properties and Dirang Berhad, land with different zoning cannot be used as comparable. Since the appellant has already misinterpreted the zoning, the whole compensation amount is being overvalued as the commercial zoning has an obviously higher value than residential zoning. Therefore, the whole comparable table is unlawful and unusable. I will proceed to my next question. So in your valuation report, there is no adjustment for shape for comparable 2 and comparable 3. However, I could not find any shape description for both comparables in the whole valuation report. Can you please explain to me what is the actual shape of these two comparables respectively?
I admit my mistakes for not making this description for the shapes, and I want to clarify now. Other than comparable 4, all of the other comparables are having the irregular shape, but I didn't make adjustment on any of these comparables is due to the reason that comparable 2 is having a very big land size, which is the 56,144 square meter, whereas the comparable 3, 42,297 square meter, and which is really big. So in my opinion, the size of the land is big enough so for us to ignore the limitations or restrictions in terms of the design or future development. So in my opinion, these comparables are deemed neither superior nor inferior to the scheduled lot. And this is why I didn't allocate any adjustment for the size for the shape factor.
However, I noticed that there is also a size adjustment in your private valuation report. Therefore, your clarification is not valid because you say you don't want to adjust the shape because of the size, but actually you already adjust for the size in your valuation report. And I want to ask the permission of the judge to show my evidence on the shape.
Yes, you may.
Okay. Can you all see my screen?
Yes.
Okay. For comparable 2, it is obviously irregular shape and has no similarity with our scheduled land. As for comparable 3, it is also an irregular shape and is nowhere similar to our scheduled land, which is rectangular shape. Therefore, I suspect that you need to have an adjustment for the comparable 2 and comparable 3. If there is no adjustment, the whole comparable table shall not be reliable, as your competency is questionable.
Like I mentioned just now, the size of the comparable 2 and 3 is really big until we can ignore the effect of the restriction and limitation on the design of future development. Because the size of comparable 2 is nearly 5 times bigger than the scheduled lot, whereas for comparable 3, it is almost 4 times bigger than the scheduled lot. So I don't think that we should have allocated any adjustment for the shape factor because it will cause overvalue.
Yeah. I already explained that I saw the adjustment of size in your valuation report. It's different, it's separated from the shape. Therefore, I don't see any problem to adjust the shape in a separate way. Thank you, Ms. Susan. I've done my cross-examination now.
Your Honor, can I make some clarification on that just now?
Yes, you may. The court allows.
All right, because the shape and size actually is 2 different factors. So based on what you mentioned just now, we should not think that there one is the combined factors for adjustment. That's why I make the adjustment for size and separately for shape, because these 2 things are exactly different for the adjustment. Thank you. That's all from me.
Okay, thank you,
Assessor,
Susan.
wait, Assessor, will you be able to advise me on this matter regarding shape adjustment? Assessor? 2 assessors. Assessor Fazliana and the other assessor. Do you have anything to advise me regarding shape adjustment?
Your Honor, I think shape adjustment doesn't matter in the comparable.
Can you give me your explanation why that is so?
Because of the basis of the comparable item is actually category of land use, locality, and category of land use, locality and express condition.
What about the other assessor? Can you advise me on the matter?
I think, as for me, I think the shape method is not really can into the comparable, into the factor of adjustment.
But do you agree that the reason is because of the size, which is too big? That it doesn't matter what the size of the comparables are?
Yes. The size is big enough to eliminate the shape factor.
Okay. I shall take that into consideration. Legal advisor, thank you so much.
Okay. Thank you, Ms. Susan. I've done with my cross-examination now. I would like to pass to my esteemed colleague, Mr. Fa'imal, to conclude the case.
Your Honor, I have finished my examination and cross-examination with the leave from court. Now, I would like to request for court adjournment if there is no objection from my esteemed colleague.
But don't you have any summary or any appeal to be made to the judge before you ask for adjournment?
As far as we do now, we have no appeal to appeal from the court, Your Honor.
What about legal advisor? Do you have any final words of any summation of our proceeding today?
Yes, I do have. To sum up, the whole comparable table is unlawful and therefore unusable. First, Ms. Surveyor Susan is aware of the general basis of choosing the comparable with same category of land use. However, she still purposely used the comparable with different category of land use to mark up the compensation value, as the building category of land use is possessing a higher transaction price than agriculture category of land use. Besides, there is no documentary evidence for zoning, and commercial zoning is merely based on her assumption, based on the word high possibility. Ms. Surveyor Susan is also aware of that we shall take the zoning plan from DBKL to use as reference. However, she still tried to adopt the hearsay commercial zoning instead of the lawful zoning plan from DBKL. This is because the land with commercial zoning possesses a higher transaction value than the land with residential zoning. Therefore, she had tried to mark out the compensation value by purposely choosing the unlawful zoning. Hence, I conclude that the whole PV comparable table is made under the mala fide of Ms. Surveyor Susan to purposely mark out the compensation value with unlawful action. Hence, the whole comparable table shall be unusable and the original compensation value by government valuer shall stand.
Thank you, legal advisor. But I must warn you that the acquisition of mala fide is very, very heavy. Yes, it's not to be used lightly. Okay, with that, I would like, I think both parties have submitted their statements and also did their examination and cross-examination, and the proceeding for this day is adjourned.
Thank you, Your Honor.
Okay.
Okay, thank you.
Stop. Pause sekejap.
Thank you everyone. We take a break for 5 minutes.
5 minutes.
Before the next group. Next group proceeding is Triple H Auto Parts Number versus Land Administration of the Federal Territory of Kuala Lumpur. Okay, be prepared for the next group. Triple H Auto Parts.
Come back at 10 o'clock, yeah? 5 minutes break.
Okay. Before that, I need to know who is actually the registrar.
I am the registrar, Dr. Saliza.
Saliza. Okay. Okay. Saliza.
Saliza, I suppose you are my group.
No, the next Triple H. Hello.
Yeah, you're under
Who is the this one is a Triple H is should be the 03. S5 15-1503. Ada nama Syrizal kat sini?
Oh, sorry, Doctor. Wrong group.
Okay, you are G2. Okay, how about the who is the registrar for the G3?
It's me, Dr. Afiq Daniel.
Afiq Daniel. Okay, you okay. So, okay, being a registrar of the court, you are not the MC of the court. You know that. Okay, you must introduce the case and then ask the witness to take oaths, and then okay, and then you also because this is online, you need to remind the judge to just not just mention about that to the judge in very harsh manner, that you must say to the judge properly, my lord, the time is over for the lawyer to ask the further question, for example. Okay, yeah, you are not the MC of the court. You must understand that you are only the registrar. Okay. Okay, we have another 2 minutes before we start. Yeah, registrar ready in 2 minutes time. Okay, at 10, because kita tak ada court orderly, registrar kena play as a court orderly as well. 10 o'clock sharp, you just say rise, and then you say that, okay, then meaning that the judge will datang to be seated. Okay. Please open the camera for Lee Ming Yao, Chua Tian Wan, Vasan Kumar, Muhammad Afiq Daniel, Lavinia, Nur Izwani, Hua Wei Chi. And then you have, okay. And then the assessor, okay, 2, 4. Okay, assistant, you don't need to open the camera.
All rise.
Okay.
Thank you, Your Honor. Welcome everybody to the hearing session this morning. I am Muhammad Afiq Daniel, Registrar of the Court. We are now sitting in a session between Triple H Auto Sendirian Berhad versus Land Administrator Wilayah Persekutuan Kuala Lumpur, court case number S5-15-1503 on 11 January 2021 at 10 AM. Hearing will commence now. Legal advisor.
Your Honor, I am Vasan Kumar, Senior Legal Advisor from the Attorney General Chambers of Malaysia. Together with my assistant, Chong Hui Ming, we appear on behalf of the defendant, Land Administrator of Wilayah Persekutuan Kuala Lumpur, in the present case before this honorable court. Now, Your Honor, I would like to pass the court to my esteemed colleague, Mr. Hua Wei Chi.
You're mute, Hua.
Please unmute.
May it please the court, Your Honor, I'm Hua Wei Chi, together with my assistant, Nurul Alia binti Mio Hanapi, appear on behalf of the appellant, OH Auto Park Sendirian Berhad, in the present case before this honorable court. Your Honor, the basis of this case is on the issue of
amount of compensation payable to Triple H Autoparts Sdn Bhd over the land which has been acquired by government. The award made by government valuer is lower than the market value with approximately 9,059,000 ringgit Malaysia, which is around 64% lower established by private valuers. Your Honor, we argue mainly on three grounds. Firstly, we submit that government valuer had chosen an unsuitable comparable as the best and most similar comparable. Secondly, we submit that the government valuer presented inaccurate fact in the determination of the market value. Lastly, we submit that the award made by government valuer is not the compliances with the law due to its failure to account for damage. Your Honor, if you please, may I proceed with my first submission? I want to call upon my witness, registered valuer surveyor Lavinia Kelvin from Jordan Lee and Jafar Sdn Bhd for examination.
Witness, please read the witness affirmation.
I, Surveyor Lavinia Kelvin, do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Surveyor Lavinia, please state your credential.
Thank you, Counsel. I am Surveyor Lavinia and I have been a registered valuer for the past 25 years. I've dealt with over 100 land acquisition cases across various states in Malaysia and am considered an expert.
All right, my first question. Let's proceed with the basis of comparison method. Can you please explain the basis? What is the basis of comparison method?
So the comparison method is a method of valuation through which the market value of a property is determined through comparisons with past sales transactions of similar properties. These property prices then undergo adjustments to account for the differences, as no two properties are the same. And then the best comparable is chosen.
Oh, okay. What is the criteria to select the best comparable?
The comparable most similar to the subject property must be selected, and in most cases, the comparable with the least adjustments will be chosen.
Right. So, what is the importance of location factor in determining the market value? Can you answer me?
So, according to the first schedule of the Land Acquisition Act 1960, it states that in assessing the market value of any scheduled land, the valuer may use any suitable method of valuation to derive at the market value, provided that the prices paid for the recent sales of lands with similar characteristics as the scheduled land, which are situated within the vicinity of the scheduled land. So it is very important, as otherwise it cannot be used for, as a comparable.
Oh, okay, thank you for your answer. So, Surveyor Lavinia.
Yes.
What is the implication of accuracy in the facts to be considered for the comparison method?
The inaccuracy of facts will cause the adjustments made to be affected, which will cause differences in the price per square meter or price per square foot and the selection of the best comparable. So this will greatly affect the market value.
All right. So there is a disparity in the land area between comparable 5 of government various report and comparable 1 in your report that comprises of the common lots, which are lots number 4719, 4722, and as well as 32661. So you also include an extra lot of 354833 in the land area of comparable 1. Please state your basis of this decision.
Okay, based on the, so the lots were involved in a compulsory acquisition in 2008 for the widening of Jalan Segambut for a joint venture. So based on the title searches and also the public announcement on Bursa Malaysia, the land should be valued together with lot 32661 and 54833, making the price per square meter 3,013 ringgit and 90 cents.
All right. So what is the importance of giving an adequate compensation?
The adequate compensation is very important to ensure that the proprietor is in the same financial position before and after the acquisition. Because according to the Federal Constitution, Section 13(2), compensation is the amount required to put the dispossessed landowner in the same position as if his property had not been acquired. This is based on the case of Chisom Cimat versus Pentadbir Tanah Daerah Krian.
Okay. Can you explain what is the claim of injurious affection in determining compensation to be awarded to a dispossessed owner?
According to Section 2D of the first schedule of the Land Acquisition Act 1960, compensation must be considered for the damage, if any, sustained or likely to be sustained by the person interested at the time of the land administrators taking possession of the land by reason of the acquisition injuriously affecting his other property, whether movable or immovable in any manner.
Oh, all right. Thank you, Surveyor Lavinia. Your Honor, I would like to call upon the defendant witness, Registered Valuer Surveyor Lee Min Yao from Jabatan Penilaian dan Perkhidmatan Harta for cross-examination.
Witness, please read the witness affirmation.
I, Surveyor Lee Min Yao, do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
So, Your Honor, we submit that Government Valuer has chosen an unsuitable comparable as the best comparable on two grounds. First, we stated that the best comparable chosen, comparable one, is with a total adjustment of 30%. Are you aware that, Surveyor Lee Min Yao, are you aware that comparable one in your report has the second largest adjustment?
Yes, I'm aware that.
All right. Do you know that this action will affect the final adjusted price?
Yes, I know that, but I need to clarify something.
Okay, Surveyor Lee Min Yao, please justify your decision in choosing the best comparable.
Okay. Since that the appellant are claiming that I'm not choosing the comparable which has not the smallest adjustment, I need to clarify something. The amount of adjustment is not necessarily equal to the similarities. First and foremost, when doing adjustment, it will involve positive and negative adjustment, which will cancel out each other. Therefore, that it depicts that the comparable may have a lot of dissimilarities, which include a lot of elements of adjustment, and even though it has a lowest amount of adjustment. Therefore, I claim that it is not suitable to say that comparable with smallest adjustment will be the best comparable. Taking the comparable for our comparable 4 as example, the total adjustment is only 5%. However, it is in my opinion that it is not the best comparable out of the reason that it has the most element that to be adjusted. Since therefore I can say that percentage that has higher on the appellant side is claiming that 30% is a very high adjustment. However, it is in my opinion that the total adjustment of 30% is within the reasonable range. Within the reasonable range of the total adjustment. Therefore, I claiming that the claim I can say that the claim on the appellant is unreasonable in this case.
All right. So, secondly, Surveyor Lee Min Yao, you mentioned that the comparable chosen is within the least element adjusted and the most similar to the subject property. According to the explanation provided by my witness, the location is the utmost importance in determining the market value of a property as stated in the first schedule of Land Acquisition Act 1960, paragraph 1/1A. So the best comparable must be chosen within the similar locality with lot 450, but you fail to take into consideration. Surveyor Lee Min Yao, are you aware of your chosen comparable is not located in the same vicinity of lot 450?
Yes, I'm aware with reasonable justification.
So, do you know that no adjustment were made to the location factor in your comparison method?
I have made adjustment in my of location on my comparison method.
Can you please show me?
Please show the evidence. Your Honor, I request to show the evidence.
I have to warn that any evidence to be shown in court must first of all be filed. An affidavit must be filed before you can show the evidence. Has the affidavit been shown for this particular document? Registrar, can you confirm
Yes.
that? Yes?
Yes, Your Honor.
Okay, all right. So I will allow the evidence to be shown.
Can you move downwards a bit to the adjustment table? It's claimed that you think that I didn't do adjustment on the location factors. However, it's obviously I have done location adjustment on all my comparables, taking into consideration of the localities.
So this table shows that you have not done any adjustment to comparable one as your chosen comparable due to the location factor. So is the chosen comparable still suitable enough to take as the best comparable despite these two major flaws?
First and foremost, the locations of comparable one is, in my opinion, it's within the vicinity of the subject of the schedule length. Therefore, I think no adjustment shall be made. And on your claim that I should choose the comparable with the located in vicinity to our subject length. In this case, comparable 5 will be another suitable comparables. However, the total adjustment of comparable 5 is negative 35%, which in my opinion, it is the total adjustment is way too high to become a suitable comparable as it has more disabilities compared to the schedule length. Therefore, I choose a comparable that I think will be best fit as the comparable to the subject property, which fulfill the element of similar characteristic, but at the same time still within the range of vicinity of our subject length.
Okay, so on this point, Your Honor, Surveyor Lee Min Yao failed to choose the comparable within the vicinity of the subject property, which is lot 450, as well as she failed to choose the comparable with the least adjustment, which is obey the comparison methods basis. So I would like to highlight that Surveyor Lee Min Yao has been extremely limited in her work, and market value derived is unreliable as the comparable chosen is not suitable. So Your Honor, proceeding with the case, we would like to proceed with the second issue, which is that the government valuer presented inaccurate facts and adjustment in the determination of the market value. According to government's report, comparable 3 and comparable 5 are located in the same locality, which is under Jalan Sekambut, but the adjustment made for both comparable is different. Comparable 3 is given a negative 10% of adjustment, while comparable 5 is given a 0% of adjustment. There's no reason stated that how government valuer derives the percentage of adjustment made. So, Surveyor Lee Min Yao, are you aware of this issue?
Yes, I'm aware, but I need to clarify something.
So, this is a yes or no question. Okay. So, are two comparables in the same location supposed to be given different adjustment for the location factor? Surveyor Lee Min Yao?
My answer is no, because your location adjustment shall be based on.
You should please stop, okay? Unless I ask you a question.
Objection, Your Honor. The council is not letting the government valuer to speak.
I will allow the witness. Counsel, I will allow the witness to clarify, to explain her answers. Otherwise, this will not be a just proceeding. I would like to hear the answer.
Okay.
Yes, Your Honor.
Just now you say that I didn't do adjustment for the same location. I need to clarify that when we're doing adjustment for location, is based on the locality of the land, not based on the address itself. Other than that, I need to admit one thing is that comparable 3 and comparable 5, I have done a mistake in stating the location of comparable 3. The location is supposed to be Jalan Segambut Dalam. However, this does not affect my adjustment because I adjust based on the locality, the surrounding, and the accessibility to take into consideration when I adjusting the locality factors. Therefore, this one is not relevant that you say that I have made a mistake in doing the adjustment.
All right, thank you, Sonia Limenyang. So, secondly, government reports has some inconsistency that need to be addressed as it will alter the market value derived. Government's comparable 5 has common loss with private valuers comparable 1. This has resulted in the government valuer obtaining a lower price per square meter of 2,900 and around 50 ringgit per square meter compared to the private valuer's price of around 3,015 ringgit per square meter. So, severely, do you know that the land area in the government report is inaccurate?
I must disagree with that because the information I obtained, in my opinion, is reliable and accurate. And Your Honor, I request to show my evidence on this.
Has an affidavit been filed with the registrar? Registrar, can you confirm?
Yes, Your Honor.
Okay, you may proceed. Witness may proceed.
Your Honor, as you can see here, here is the location, not location plan, the plan for the lot comparable 1. So, legal advisor, assistant legal advisor, please show the information on lot 32663. As you can see here, the lost hectare here is approximately 3.832 hectares. And then please show the details for lot 4719. And here the total area is 0.185 hectares. Please show the area for lot 4722. The total area is 0.213. The total land area here, when we sum it up, the total land area is 4.23 hectares, if according to the I-Plan, which is a government website, and 4.23 hectares is approximately 42,300 square meters. Therefore, it is in my opinion that our land area obtained is reliable and accurate.
Okay, so Soeli Minyao, is your I-Plan updated?
In my opinion, yes, because the I-Plan is obtained in the newest version of it.
So I would like to show private valuers evidence of the land area of her comparable 1.
Objection, Your Honor. The witness has already provided her justification for the land area.
Yes, I will allow this objection. No need. You will clarify with your witness later on, not now, not during the examination. Sorry, cross-examination of a witness. Okay.
Okay, thank you, Your Honor. So, based on the description by Surveyor Liminyao, she failed to mention the location of comparable, which is Jalan Segambut, as she stated just now, as well as the land area I acquired from our site is different from hers. So, in my opinion, government valuer is either careless or provided a small land area in order to lower the market value of the scheduled land. Therefore, the content of the report have to be checked again and ensure the reliability. So, Your Honor, my third ground of rebuttal is the government valuer failed to account for injurious affection in the award being made. According to the first schedule of Land Acquisition Act 1960, paragraph 2D, The damage, if any, sustained or likely to be sustained by the person interested at the time of the administrators taking possession of the land by reason of the acquisition injuriously affecting his other property, whether movable or immovable, in any other matter. Government valuer failed to include injurious affection in the compensation, which has caused a huge loss to my client. Surveyor Lee Min Yao, are you aware that damages likely to be sustained by the disposed owner due to land acquisition must be compensated?
Yes, I have taken into consideration when I'm doing this valuation.
Okay, thank you. Do you know that injurious affection affecting that disposed owner's other property must be compensated?
Yes, I have aware and I have taken into consideration.
Okay, but explained by my witness, there shall be no acquisition without adequate compensated. The defendant witness has failed to do so. Therefore, the amount of compensated awarded to the appellant should be higher. Thank you, Surveyor Lee Min Yao. I finished my examination and cross examination. Sorry, Your Honor, I finished my examination and my cross examination. Now, I will hand over the session to my esteemed colleague, Mr. Vasan Kumar, legal advisor of the defendant.
Thank you very much to my esteemed colleague, Mr. Phua Wei Chi. Now, Your Honor, I would like to, before I proceed with my case, I would like to examine my witness, Surveyor Lee Min Yao from Jabatan Penilaian dan Perkhidmatan, Halte Kuala Lumpur.
Witness, please read the witness affirmation. Sorry, Your Honor, my mistake. No need to read the oath.
Surveyor Min Yao, can you please explain regarding your credentials? Surveyor Min Yao, your mic is unmuted.
My mistake. So I'm a Surveyor Lee Min Yao and I'm from the JPPH of Kuala Lumpur. And I have worked as a registered valuer with my registered license V177 for 20 years since 2001.
Right. Surveyor Lee Min Yao, can you elaborate regarding your experience in the field?
So before I was transferred to the JPPH in Kuala Lumpur, I have worked in 3 different states in the government department. And I have carried out my valuation works related to land acquisition for nearly 15 years.
Right. Surveyor Min Yao, can you describe the valuation that you have done in this case?
I was instructed by the land administrator of Wilayah Persekutuan Kuala Lumpur to carry out the valuation on the scheduled land, Lot 450, for the compensation claims on the land taken and other losses resulted from the intended acquisition for the project Sambungan Lebuh Raya Juta Ulu Kelang, Duke 2 for Wilayah Persekutuan KL. In arriving at the market value of the scheduled land on the 27th September of 2013, which is the date of valuations, I have adopted comparison method. The details of my comparables are obtained from my department, which is Valuation and Property Service Department, JPPH. The comparable chosen is located within the vicinity and to the schedule land, and the date of transaction of comparable is between 11 October 2011 to 19 September 2013, which is before the date of valuations. And I have made sure all the transactions is arm's length transactions. All of the 5 comparables has been analyzed and adjusted for the factors such as time factor, location, tenure, category of land use, express condition, land size, terrain, planning, and land shape. After making the adjustment on all of the factors of the comparables, the market value derived is 3,200 ringgit per square meters.
Right. So Baby Miao, when you made your adjustments in your comparison method, did you take into account the accessibility in the location?
Yes, my answer is yes. When we doing adjustment on the location factors, the factors or the element of accessibility shall be included together with the location factors.
All right. So Baby Miao, did you take into account the adjoining lot 449, when doing this valuation?
Yes, since the lot 449 has the same provider with the schedule land, which is the appellant in this case, the planning of lot 449 will be taken into consideration when doing these valuations. Since that the planning provision of lot 449 is zoned under mixed development, which is commercial use with a plot ratio of 1 to 2 and residential use with a density of 120 people per acre, the scheduled land is valued as a vacant land under residential use with a density of 120 people per acre.
So Baby Miao, in your professional opinion, do you think that the scheduled land should be awarded for injurious affection and severance?
My answer is no. Injurious affection and severance is not recommended for the scheduled land, as the land acquisition will not cause any damages on the scheduled land. This is because the land acquisition only involves the portion of land that has been separated physically due to the previous acquisition. The acquired area involves the whole area of the portions, therefore no damages are sustained by the acquired land. Other than that, I also aware that injurious affection can be claimed on the adjoining lot with the same proprietors. As for the adjoining lot 449, no award on injurious affection and severance is given due to the fact that, in my opinion, the land area is still optimum for development and the land shape is not affected. Therefore, there is no damages on the land that will cause deteriorate in market value of lot 449 and no injuries shall be awarded.
So Baby Miao, do you think that the compensation awarded by your side is adequate?
Yes, this is because I have taken into consideration of all the factors, including the effect on the adjoining lot 449. The compensation awarded is based on the principle of no gain, no loss, where the position of the landowner after the acquisition is same as before the acquisition.
Right. Thank you very much, Surveyor Miao. Your Honor, referring to the grounds in the payment, they claim that in lowering the market value, the government, our side, the defendant, presented inaccurate facts in determining the market value. They claim that we've chosen an unsuitable comparable as the most similar comparable. And lastly, they claim that we had not made an injurious affection award. However, we object to these grounds by the fact that the private valuers also has made errors. The private valuers have made errors in their application of their comparison method. The comparable chosen by the private valuer is unsuitable, in addition to the fact that the defendant affirmed that there should be no claim for the injurious affection. So, Your Honor, I would like to request to call upon the appellant's witness, Surveyor Lavinia from Jordan Lee and Jafar Sundiran Berhad, to take the stand for cross-examination.
Yes, you may.
Thank you very much for taking the stand, Surveyor Lavinia. So, firstly, in reference to the private valuers report, what we found is that there are factors of adjustment for locality and accessibility, in which there have been adjustments on both these factors. Yes, correct?
Yes.
All right. So my question to you, Surveyor Lavinia, is: have you adjusted the location and accessibility separately?
Yes, I have.
Do you think, in your professional opinion, that it is accurate to adjust both the location and accessibility separately?
Yes, I do, because the location refers to the locality itself. In this case, the comparables are in different locations that have different characteristics, And this has nothing to do with the accessibility in itself. And then the accessibility, especially because this is concerning road widening, the accessibility needs to be looked at separately.
So your justification is that both these factors should be adjusted separately, correct?
Yes, for this case in particular, yes.
All right, that is your professional opinion, Surveyor Lavinia. But according to the help from a court case known as the Nusantara Daya Sendirian Berhad versus Pentadbir Tanah Johor Bahru 2020, they claim that the location, access, layer, all these are three parts of the same pyramid and multiple adjustments cannot be made. They all should be under one single adjustment. So before I move on, I would like to ask you, do you have any remarks regarding this?
So for this case, it has to be looked at separately, because if we look at the comparables provided by both the appellant and the government, and the defendant, it is seen that the location of the comparables are actually in very different types of locations. So you need to give separate adjustments for those, because, for example, Mont Kiara and Hartamas is very different from where the subject land is, that is near the KTM station in Segambut. So it needs to be looked at separately. That's my opinion.
All right. In the case of the defendant's report, both the location and accessibility factors were adjusted together, as mentioned by Surveyor Miniao a moment before. So what I would like to reaffirm is that in making these adjustments separately, the private valuer has in fact double counted for these factors. So I would like to move on to the planning and express condition factors. So in reference to the private values, the appellant's report, in reference to the appellant comparison method, what we found is that they have made an adjustment for planning and express condition together. So Surveyor Lavinia, I would like to verify this. Is this true?
Yes.
You have adjusted them together, yes?
Yes.
So do you know that the planning and express condition are two different factors?
They are two different factors that are interrelated.
Interrelated. So do you think in this case, there should be two different adjustments for these two factors?
So in this case, if we look at the land in question, in the express conditions, it stated that the pembangunan di atas tanah ini hendaklah mematuhi perintah pembangunan yang dikeluarkan oleh Datuk Bandar Kuala Lumpur, which means in the express conditions, it is stated that it needs to follow the zoning or the planning, and therefore it was considered together.
Okay, understandable, Surveyor Lavinia. And I would like to reaffirm that in making the adjustments for the planning provisions, you had not included the specific planning provisions, correct? Whether it is 120 PPA, people per acre and their density and whatnot.
Yes.
So can you really justify that by combining them, you've made a very accurate adjustment, especially considering that you've fallen short on the planning provisions?
So basically, the evidence that we get is based on our visit to the JPPH, which is, responsible for providing the information. So we have gotten the evidence based on what they have given us, and that is what we have used to calculate. So we assume that whatever the authorities give us is the correct use, and for the we did not take into account the density. Is that what you're saying?
Yeah.
Okay, I think I need to admit this mistake, because in terms of the density, we did not take into account the density. Yes.
Assessors, I would like for you to take this into to take down the notes, related notes regarding to the admission of the witness just now about the omission, to take into account the density, because this will affect the composition.
Right, Surveyor Lavinia, may I move on?
Yep.
All So just to reaffirm our point, the planning of the land use is the land use that is compatible with the future development planning, whereas the express condition is the land use that is legally bound to as endorsed in the document of title. And there are times where both the land use and express condition, the planning and the express condition are not compatible with each other. And this case is one of those. So with that, we reaffirm our point that these should have been two different adjustments. All right. So next up, I would like to talk about the factors neglected in your comparison approach. So the private valuers have neglected to include three important factors in making your adjustments, Your Honor, namely the terrain, the category of land use, and the land shape. So Surveyor Lavinia, my question to you is, do you think that the terrain, category of land use, and land shape will affect the market value of the land?
So I will, yes, they, in normal circumstances it will.
However, you claim that the particular case that we're referring to is not a normal circumstance. Would you be able to justify your point?
Okay, so for the terrain, basically, so it was observed based on our inspections on November 7, 2014, that the terrain of the scheduled land as well as the comparables were relatively flat, and therefore no adjustments were necessary. That's one of the main reasons why we did not include it in the adjustments.
All right, understandable, Surveyor Lavinia. So in regards to the terrain, let's talk about, let me briefly reaffirm the differences in the subject property and the comparable that they have chosen, which is their comparable one. So generally, both these properties, Your Honor, are flat and undulating. However, within the subject property, we also have a portion that is sloping. So when you look at the first schedule, it is clearly mentioned that you have to take the particular features of that land into consideration when assessing the market value. So the terrain factor does have to be considered as well in this scenario. In terms of the category of land use and land shape, you do admit that these factors have an effect on the market value, do you not, Surveyor Lavinia?
Yes, I'd just like to clarify something on the terrain, because based on our observation during our site visit on our inspection date, we did see that it was flat and undulating, so there was no slope. Okay, so regarding the category of land use and the shape, yes, it is important.
All right. So you admit in neglecting that these three factors, at least in the category of land use and land shape important, the land shape factor, that you have derived a market value that needs further review. Do you not?
So basically, in this case, the category of land use, as we all know, must be taken into consideration with the express conditions. And especially in this case, where a lot of the comparables are unconverted or nil. So therefore, we have included that into basically the express conditions point that was made earlier, in the sense that because they do not go against each other. For example, the subject land has a building as its category of land use, and then the express condition states residential, and so it is basically considered one in this case because there is no further adjustment.
So Surveyor Lavinia, what I'm getting from your answer is, instead of just combining the planning and the express condition, you have combined the planning, the express condition, and the category of land use as one factor.
To some extent, yeah, it was considered. It's not the condition itself, but it was considered in determining the factors.
All right. So let me summarize regarding the comparison method.
Sorry, also regarding the land shape, I have not clarified, is that each lot has its benefits and drawbacks. Therefore, different developments will find different shapes more advantageous to their development. And in this case, where the acquisition is for a road, it is completely irrelevant. So therefore, we did not include the land shape into this particular case.
All right, before I move on to my conclusion, my remarks in regards to the land shape is that the subject property and the first comparable applied by the private valuers are the only properties with a similar land shape. They are irregular in land shape. However, each of the other comparables have a regular land shape. So when you make the adjustment for the land shapes, the value for the rest of the comparables or the factors of adjustment or the total amount of adjustment might reduce. And that was the logic that the PV had brought forward, Your Honor, in terms of the best adjustment to be chosen. So again, I reaffirm that their comparison method would probably need further review. So in their comparison method adjustment, they have made 6 adjustments, all right? 6 adjustments. In one of these, they have combined planning, the planning factor, the express condition, and the land use. On top of that, they have double counted for the location and accessibility. And on top of that, they have missed out 2 other important factors, which is the category of land use and land shape. So it really begs the question whether the previous comparison method report is even reliable at this point. So moving on, Your Honor, I would like to refer to the third ground of the opinion, which is the injurious affection. I would now like to examine their case for their injurious affection. Surveyor Lavinia, is the injurious affection claim, in this case, on the adjacent lot, lot 149, lot 449?
Yes,
rather
it
than
is.
the festival land? Yes, it is. Yeah. Right. Surveyor Lavinia, you have derived a market value depreciation of 30% for the injurious affection, no? Correct?
Yes, correct.
Could you briefly explain how you derived this depreciation of 30%?
So based on the explanations given in the private valuation report, where it states, there's excess inconvenience of access and due to the elevation of the road, and then also eyesore and noise and dust. Based on these factors, the 30% 30% depreciation is made based on the collective damages through my years of experience. And basically, the claim here is that because the intended use of the land is for residential purposes, and through verbal inquiry from our appellant, it is stated that the adjoining lot 449 is to be used for residential development, and all these factors will significantly affect the value. That is how we derived 30%.
All right. So within your injurious affection claim, you make 3.
Okay. Could you repeat that?
All right. Within your injurious affection claim, Surveyor Lavinia, you make 3 important points as to where the damages are situated. Yes, the inconvenience of access, the noise and dust pollution, and the eyesore or the bad feng shui. Correct?
Yes.
All right. So let me question you regarding firstly the inconvenience of access. Yes. Are you aware that lot 13706 is part of lot 449 and lot 13705, which is part of the scheduled land, share the same road frontage?
Yes.
All right. So do you know that the accessibility of lot 13706 is not reliant on lot 13705, the portion of the scheduled land that has been acquired?
Yes.
So if you know that these 2 lots are not reliant on each other for their accessibility, where have you derived the inconvenience of access from?
So the inconvenience of access is not the inability to access, and it's shown that it is because the slip road that is to be constructed will be slightly elevated to connect the new elevated highway to the ground level of Jalan Segambut. And that is what will cause the inconvenience of access because it's located very near Lot Baru 13706.
All right. However, the road frontage itself is not affected. Yes, it will still be present after the acquisition.
Yes, yes.
Yes. So there cannot be an inconvenience in access.
This has nothing to do with the road frontage. It's about the elevated slip road.
And Surveyor Lavinia, if I may, how does the elevated slip road affect the fact that they both have the same road frontage and thus the accessibility is still very reasonable, still very applicable?
So basically, the elevated slip road it's because of the way in which anyone who wants to enter into the lot 449 will have to go through the slip road, and because it will be elevated, then the access point to lot 449 will be affected.
All right, it's all right. So, Lavinia, let us move on to the next point, which is the noise and dust pollution that you've claimed for damages as well. Right. So, Lavinia, are you aware that there already exists a Duke Highway over lot 449 with heavy traffic? Right.
Yes.
So, do you think that the issue of noise and dust pollution that you're talking about in your claim for injurious affection already exists before the acquisition?
So basically, the reason for the acquisition is that the construction of the intended acquisition will alleviate the traffic jams that regularly occur along Jalan Duta and Jalan Segambut. Therefore, it's not a hypothetical situation that the noise and dust will exponentially increase, because it's not just now one channel. You're trying to channel traffic from another area that's known for traffic into the same place. So there's definitely going to be a considerable increase in the noise and dust.
All right. So, Surveyor Lavinia, are you able to, considering that the Duke Highway that already exists has very heavy traffic, are you able to quantify the supposed increase in noise and dust pollution?
This is based on my experience, because if you, especially when we take into consideration the intended use of the landowner, that is to develop residential properties on the subject property, having a very even busier highway with more traffic and more noise and more dust will definitely reduce the value, and that is the reason for this depreciation.
All right. So lastly, you talk about the eyesore, correct?
Yes.
So do you know that concrete structures are common in the Kuala Lumpur area?
Yes.
Do you know that the lot 449 is actually existingly already faced with concrete structures such as Jalan Segambut?
So currently it is faced with concrete structures, yes, but in this case, because there is going to be an elevated slip road in addition, and all of that, then it will definitely increase the kind of obstruction in view in the regarding the eyesore factor. Like stated in the case of Chisum Cemat versus Pentadbir Tanah Daerah Kerian, where obstruction of view can actually be used. So the fact that there's going to be extra elevations will definitely be a cause for depreciation.
All right. So, Your Honor, let me summarize my case. So, based on the case of Dr. Muridesu versus Dr. Muridesu Sokalingam versus Superintendent of Lands and Surveys 1983, so claims relating to surveillance and injurious affection are often difficult to substantiate. In the present case, it is even more so on the particular facts. To succeed, a valuer must quantify such damages realistically and convincingly. Thus, it is the opinion of the defendant that the appellants have failed to prove the injurious affection upon the adjoining lot 449, with any substantial evidence. With regards to this claim, the private valuer failed to explain the deviation derivation of the depreciation in market value, which is 30%. Their report is merely descriptive on the damages sustained by Lot Baru 13706. And now, I would like to pass it on to my esteemed colleague, Farichi, if he has any concluding
Your Honor,
remarks.
I'm sorry to interrupt. I want to inform you that the hearing time has up.
I will allow for the counsel to give his concluding statements.
All right, thank you, Your Honor. I would like to stand with my stand that clients should be given, if given an inadequate amount of compensation, which is in a higher rate. So, based on the cost examination by my time just now, government valuer has chosen an unsuitable comparable as the best comparable and also the most similar comparable. They failed to choose a least adjusted of the best comparable, and as well as they have failed to choose a comparable within the similar locality. So secondly, government presented an inaccurate facts in the determination of the value. Surveyor Livinia just now had admitted that the mistake has been done by her to describe the location of the best comparable has chosen. So third one, government valuer has failed to account injurious affection into a consideration. The injurious affection has been caused to my client, so that Triple H has due to a huge loss. So, Your Honor, I would like to ask for court adjournment.
Okay, I will allow that.
Thank you, Your Honor.
Court is adjourned. Dah, okay.
Okay, thank you everyone. Okay. And then we have another 5 minutes. I think it's not right for me to actually to comment or whatever until the last group will present on 13th of this January at 4 p.m. And then if tomorrow will be the MCO, we still have to conduct this presentation on 30, but I'm from my home. Okay, everybody will be from your respective home. Okay, with that, I think anything to ask before we have another 5 minutes before your next lectures of your business evaluation. Dr. Has anything to say?
Hello.
I think yes.
Doctor, Lekon here.
Yeah.
Just, can you hear me?
Yes.
Just wondering whether we need to go back to campus at the March, because the announcement by IPT.
I don't know until further notice by the activity, because based on the Prime Minister announcement today.
Or the MC? Okay.
Whether okay.
Okay, thank you, Doctor.
Dr. Has anything to say?
I will wait until the next group as well. But
Okay.
I have provided some comments in the WhatsApp group. Please read that comment first.
Yeah. Good comment, Dr. Has. Okay. Any other want to ask questions?
Tak ada, no question. But I just would like to advise all students, because of the cases are very, very high nowadays. Please do not go out unless very necessary. Even though there's no MCO or whatever, please observe. Please protect yourself. Okay?
Okay.
We don't want any cases among the students.
Mana student of University Malaya?
Yes.
Doctor, when we need to submit the written submission of the assessor?
Okay, on with 14, because to be fair to the last group.
Noted. Thank you, Doctor.
Okay.
Okay, I think that's all. I need to go to my other class. I have class at 11.
Okay, thank you, Dr. Has, and thank you everybody. Until we meet again on 13th, 4 o'clock. Okay.